This is the American Law Journal.
Police stop you on the highway. They want to search your car. What are your rights under new laws? And is race an issue? Good evening. I'm Christopher Naughton. Welcome to the American Law Journal. We kick off our 25th season on the air tonight. We're going to look at the state of search and seizure in our nation. And I have to tell you, we're going to share some disturbing video on traffic stops, searches, and shootings, especially as it relates to race. But first, the Pennsylvania Supreme Court has changed its opinion on Fourth Amendment protections. What does that mean to you if you're pulled over? Gina Passarella with the Legal Intelligencer reports.
Why don't you just pull right over the side, right there, right there.
Am I being detained?
Pull over to the side, right there.
Am I being detained?
If freedom of speech, the First Amendment, is the most precious of our rights, then the Fourth Amendment, protection from unreasonable search and seizure, is right behind it. To the framers of the Constitution, illegal search and seizure was deeply personal. British soldiers, through writs of assistance, had a blank check to search homes and personal belongings. It's likely why they included protection from such searches in our Bill of Rights. In the 1950s and 60s, the liberal Warren Court expanded Fourth Amendment rights. But many legal scholars argue those rights have been chipped away by conservative courts of the last generation, including recently in Pennsylvania.
A new state Supreme Court ruling means police can search your car if they have probable cause without a warrant.
They went into pretty much detail, I think, that helps law enforcement now to better understand. It doesn't matter if, even if the person's under arrest or they're going to impound the vehicle, if the police have probable cause, then that vehicle can be searched.
It certainly makes it harder to defend a case based on search and seizure grounds in Pennsylvania.
But it's not all going in one direction. Of late, the U.S. Supreme Court said no to officers placing GPS tracking devices on a suspect's car without a warrant. No to police accessing data on seized cell phones without judicial approval.
Thank you.
And last year, a New York federal court ended former New York City Mayor Bloomberg's controversial stop and frisk policy. Concern for eroding Fourth Amendment rights, especially as it relates to racial profiling, is finding support on both the left and right, which is why this year and next and in the decades ahead, U.S. and state Supreme Courts will undoubtedly grapple with what is or is not an unreasonable search or seizure. For the American Law Journal, I'm Gina Passarella.
All right, three guests with me tonight and your telephone calls as well. Kevin Mincey joins us for the first time tonight, former assistant DA in Philadelphia. He's a criminal defense attorney with Mincey and Fitzpatrick in Center City, Philadelphia. Michael Schaller joins us for the first time this evening, spent 25 years, over 25 years, as a major and chief of staff for the New Jersey State Police. He's now with King Kitrick in Brick Township, New Jersey. And John Morganelli, I don't want to say returns to the scene of the crime, but in a sense he does. District Attorney, Northampton County. He has been a DA for almost as long as we've been on the air, and John has joined us several times over those last 20 years. 1-800-426-4625. If you want your question answered, call in early or we won't get to it, or write to us at info@lawjournaltv.com. John, I don't know if you know this, but I'm a former prosecutor from New Jersey. And going back to the last century, in the 1980s, if our officers wanted to get inside a trunk or a compartment, they needed a warrant. Sometimes they needed a warrant to get inside a container within a container. Rarely did an officer have the right to ask you to step outside a car unless his safety was in danger or there was a crime afoot. I don't know about you guys, but I think a lot has changed since those days. Those days are long gone, Kevin.
Oh, certainly, certainly, and now, especially with the recent decisions from the Pennsylvania Supreme Court, the police officers are being, I guess, afforded a lot more credibility than I frankly think that they deserve. I think that over the last few years of my practice, we've seen a number of police officers find themselves in trouble with the law, whether it's indictments or problems with their evidence or problems with their cases. And so to now allow police officers to order people out of vehicles with just on probable cause to say, well, I smelled some marijuana, something as subjective as that, to me is a very dangerous thing.
And let's clear this up, John. So a pretty major sea change. Again, the state of Pennsylvania had always had afforded more rights to its citizens. And I know a lot of people don't understand this. When a Supreme Court comes down with a decision, a state can actually afford more rights to its citizens. So in Pennsylvania, they said, even though the feds, the U.S. Supreme Court has said all police need is probable cause at the scene to search a car, in Pennsylvania, you used to have to get a warrant until a few months ago.
That's correct. And what has happened in Pennsylvania is that Pennsylvania has now been brought in line with the federal standard. And for a long, long time, you're correct, Pennsylvania afforded more protection under the Fourth Amendment than the federal rights recognized. But now we're on the same playing field. And I disagree with my colleague, Kevin, on this issue. You know, I have confidence in our police. Absolutely, police make mistakes, and sometimes there's bad police. I mean, I prosecuted probably 40, 50 police officers over my career. But for the most part, they do their job. And quite frankly, at some point, if they do find, you know, if they believe there's probable cause and they find contraband, at some point, if there's a motion filed by a defense attorney, they have to articulate that probable cause in a courtroom, just the same that they would have to do on an affidavit to go get a search warrant.
You know as well as I do that motions to suppress, you know, go in favor of the prosecutor, probably over 90%. But John makes a good point, Kevin. What's the big deal? If we've got probable cause and we know that the officers are going to have to make that stand under a motion to suppress, are we really losing that much? Does this case, because you use kind of provocative words like this case is dangerous, now police will open up the door and smell a lot more marijuana in cars and then not find anything.
I'm certain that they will. And you know, I think it's dangerous in the sense that, you know, it shouldn't just be, oh, well, we'll let the court sort it out. You know, oh, I'm claiming that I smell marijuana, but, you know, you'll get your day in court, and so we'll get a chance to challenge that. You know, a lot of times judges have preconceived notions. They hear a lot of these motions all the time. They hear a lot of the same police officers testify all the time, and they get comfortable hearing them. And, you know, they're more likely to lean in favor of the prosecution in those situations.
Okay. And, you know, Michael, let's go to you. Again, you spent over 25 years with the New Jersey State Police, and now in the last couple of years, you're representing criminal defendants in New Jersey. New Jersey kind of went down this track, did they not? I mean, at one time, New Jersey had, let's say, additional sanctions or protections for its citizens regarding search and seizure. Then it went the route that Pennsylvania's gone. They went to basically what the Supreme Court says, which is, again, if a policeman finds that there's probable cause at the scene, boom, he can go into the trunk. Well, but what did New Jersey do? Because from what I understand, it really hasn't hurt you that much in the state, or it hasn't hurt prosecutors or defendants that much in the state.
Well, the law in the state of New Jersey currently is that if a police officer establishes probable cause and the stop was unforeseeable, as it wasn't planned, he also or she needs to have exigent circumstances. So we really are more in line with what it sounds like the Pennsylvania law was previously to this past decision. What I would say about the decision in Pennsylvania is it brought clarity. I don't think that New Jersey has that clarity right now. Trying to determine when exigency exists, there's about 9 factors that the courts have listed that can make that determination. Not one of them dispositive, but it makes it very difficult for the police officer to determine whether he or she has exigency.
Well, and you see, and that's the interesting thing, because probable cause at the scene, again, if you will, the officer is kind of playing, not judge and jury, but he is playing judge. Okay, so that may be bad for your clients, good for you, John. But the bad news for you, John, is if he makes the wrong call at the scene, there's a better chance that that's going to get flipped on a motion to suppress.
There is some risk to that because, as you know, a neutral magistrate normally would look at the facts put forth in an affidavit of probable cause. But, Kevin makes a valid concern, and that is our judges routinely approving and denying suppression motions. But the same could be said for approval of search warrants. A lot of magistrates see this. They're not lawyers, many of them. In Pennsylvania, we have lay people who serve as magistrates, and they look at a police affidavit and they sign it, and it goes off. So, we're not losing that much. And one point I want to make about this is that we're talking about reasonableness. The search still has to be reasonable. For example, under the new law as I see it, if the police are looking for a stolen television set, for example, they can't go into a car and search the glove compartment. I mean, a big television set can't be in a glove compartment. They may still need search warrants to search certain containers under certain circumstances. But if it's a whole car search, yes, they could go in your trunk. They could go into your pocketbook.
Well, we know that if they stop a car, it's rare. It's less than the majority of the times that they're actually looking for something specific. They've made a stop based on a traffic violation usually, and then Now we can either go and look for something, whether it's a fishing expedition or they're looking for something specific. The Supreme Court justices in Pennsylvania expressed some concern. The first is Seamus McCaffrey, and he wrote the majority opinion. He said that this case, the consistent and firm requirement for probable cause is a strong and sufficient safeguard against illegal searches of motor vehicles. There is no compelling reason for Pennsylvania to afford greater protection than the federal standard. On the other hand, you had Justice Deborah Todd, who wrote the dissenting opinion where she said, by so doing, our court heedlessly contravenes over 225 years of unyielding protection against unreasonable search and seizure, which our people have enjoyed as their birthright. So let's just sum it up here, because we're going to move on to some other things. In the end, is this going to hurt motorists in the state of Pennsylvania? Is this something that's should be a cause of concern when we talk about our constitutional rights?
I think that it will. I think that something as ambiguous as being able to say that you smelled burnt marijuana, which allows for you then to not find any marijuana or contraband in the car, but still search the entire vehicle, and maybe you find that firearm that you didn't know was there, or something else that causes someone to go to jail and have to face criminal prosecution. I mean, that's a great danger to the citizens of Philadelphia.
Gotcha.
I mean, Pennsylvania.
And we know where you stand, John. Obviously, you disagree with that.
I don't agree with that.
Let's take a look at something else that's been very troubling in our nation, from Ferguson, Missouri, and also some of the things happening a little closer to our home in New York and New Jersey. We know that last year, I think it was last year, Mayor Bloomberg's stop and frisk policy was overturned in the courts of law in New York, and because there was racial bias in those people who were being stopped and frisked. The same thing in Newark, New Jersey, and there you see the article up on the screen. 3/4 of Newark pedestrian police stops had no constitutional basis. The Justice Department finds, I think it was 85% in stop and frisk. These numbers are really troubling. Where does this leave us, Kevin? Where are we?
I mean, I think that we're kind of in a similar situation. We're in the same situation we've been in for a very long time, which is that police officers are being afforded the opportunity to pretextually stop people and hide it under the guise of stop and frisk. In Philadelphia, we deal with Mayor Nutter's stop and frisk plan in dangerous areas of the city. And dangerous areas of the city is a very vague proposition that covers a large part of the city that deals with black and brown people. So not a lot has changed in the sense that pretextual stops are something that have gone on throughout the course of our history in this country. The problem is, or what we need to do, is try to figure out a way to stop that. And obviously in New York, the federal courts have stepped in and done their part to do that.
Right. They said it was unconstitutional, and I think either the Department of Justice or maybe, Michael, after this report, maybe the state of New Jersey will do something. I think you were the one we spoke about this. New Jersey at one time was the poster child, for worse, not for better, regarding racial profiling. Maybe the state will take some steps here, because you look at 3/4 of the stops are unconstitutional, or stop and frisks are unconstitutional, and the vast majority are people of color. It's got to be cause for alarm. I don't care whether you're a prosecutor or if you're a defense attorney.
I would agree with you, Christopher. What I would say to you, when you read that report, what it gets to certain things about report writing, training, supervision, internal affairs investigations, and things of that nature. And I think ultimately when you're talking about any type of reforms within a police agency, those things are going to encompass the entire agency, and I do believe that it needs to be that kind of effort. I believe the Department of Justice is going into Newark, and I believe that the city and the department have agreed to enter into a consent decree whereby there'll be federal monitors that will come in, recommend reforms, and then oversee to make sure that those reforms are implemented.
Well, if 85% of those stopped under stop and frisk in New York, and a larger number, over 90% in Newark, were the ones who were stopped and frisked in Newark, New Jersey, should we be so surprised with some of the things that we're seeing right here? Let's take a look at a couple of, again, rather provocative and disturbing video clips. This first one comes from Ohio. A gentleman called 911 and said that a man was brandishing a gun in an aisle in Walmart in Ohio, and that something needed to be done. Now, this gentleman actually did go into one of the aisles and picked up one of the guns that Walmart actually has on its shelves. It's a pellet gun, and watch what happens next. Here come the police. They shoot the gentleman. They rush in.
Sir, what's going on?
And they shoot him again.
shot to the store.
That gentleman, 22-year-old man, died a little bit later that day. This is from South Carolina recently. A stop for not wearing a seatbelt. Man goes to get his license. Shot once, twice. Shot at 3 and 4 times.
Get on the ground! Get on the ground!
Despite having no weapon.
Put your hands behind your back. Put your hands behind your back. Put your hands behind your back. Put your hands behind your back.
I know that we don't have the entirety of the videos that we can show to you tonight, but as I look at that, is it that much of a leap to say that sometimes we're shooting first and asking questions later?
I think that's absolutely right, and it just shows you the value of videotapes, cell phone video recording by citizens, and then other obviously surveillance videos that can be used to kind of monitor these incidents and see what actually happens. Because when there are no tapes and when there are no videos of what happens, what ultimately happens is that police officer feels that feels some type of threat to them, to their safety and their liberty. They fabricate some version of the event, and then it's up to the defendant to sort it out in court to try and get their day in court and say, oh, well, that's not really what happened, when the video or the tape never lies.
Disturbing, no?
Absolutely, and I think that what's going on out there, Chris, is first of all we have a proliferation of guns in a society of the United States. Police officers, every time they stop someone, their life is in danger, and they are acutely aware of this problem. And then we have some police who overreact, and they have a responsibility to act within the guidelines. But sometimes, because of their own fear, because there's so many people out there, criminals walking around with guns, easy access, that the police are jittery out there, and some cops overreact and they shoot, and it's wrong. And getting back to the issue of racial profiling, this is a problem, a long-standing problem we've had in the United States. Back in the early 90s, when I was president of the State DA's Association, I recommended, and we passed a resolution in Pennsylvania, to have a statewide study by the Attorney General on racial profiling stops by police in Pennsylvania, following what New Jersey did. It never happened because the AG at the time wouldn't go forward and do it. But this has been a problem, and everybody in law enforcement has to understand, and anybody who says that we don't have racial profiling is just lying to themselves, because it happens out there, but it's vigilance. We need to educate our police, and we can't put up with this kind of stuff. As the head of an agency, we have to treat all citizens the same, and we have to recognize that these things do happen.
And if I could just join in, and on some instances, John and I will agree on some things, and I think that we can probably both agree is that the sale of these pellet guns, just thinking about the Ohio incident,
yes.
These guns are so lifelike and so realistic, and it puts everybody in danger. It puts the citizens, and then it puts the police officers in a precarious position. In Pennsylvania, and something that we're dealing with in Philadelphia, is that you have these stores who are selling these pellet guns to kids, and all they do is pick the little orange piece off of the cap, and now it looks like a real Uzi or a real gun. And there are laws in Pennsylvania to prevent stores and manufacturers from selling these to people under 18 years old, under 21 years old. And it's up to the police and the prosecutors to not only prosecute these kids who are carrying these illegal pellet guns, but prosecute the stores who are selling it to them in our neighborhoods, because you're putting everybody at risk.
Right. Walmart is probably going to change where they put their pellet guns. Mike, one of the things that, as I look at this, that gives me some hope is that when cameras are about, it seems to change people's behavior. And I know last couple of years ago, we took a look at a program about whether citizens have the right to videotape police in action. And I think most of the circuits, I know the Third Circuit where we're all in, says, yeah, it's fine to go ahead and do that. But have you found with the New Jersey State Police, and maybe now even as a criminal defense attorney, that cameras make everybody behave better, and that we're likely to see less police misconduct because of this very fact, this technological fact?
I think without a doubt cameras make everybody, put everybody on their best behavior. I think more importantly what it brings is transparency. I think anytime you have a police agency, there's going to be a division between that agency and the people that they police. And I think an idea of perception. So I think the closer we can narrow that gap, I think transparency is the key to that. I think the cameras, more so than putting everybody on their best behavior, it brings transparency to these interactions.
I would disagree with Mike on that, in the sense that it doesn't put the police officers on their best behavior, at least not in my experience. What it often does is that it causes the police officers to ratchet up their bad behavior, which means they're going to grab the cell phone and try and destroy the video. They're going to smash the phone on the ground. They're going to do what they can do to get rid of that video because they don't know that they're being recorded as soon as it starts. They typically don't notice it until they're in the midst of whatever they're doing that's illegal or wrong. And so then what they feel they have to do to protect themselves from prosecution is they take the video, they try and destroy it, they try and do whatever they can do to save themselves because they've already gone down the path of acting as they normally would when they don't have a camera on them.
Well, I don't know any police that act like that. Maybe Kevin does. But let me say this, the trend now is to have the police wearing the cameras.
Yeah,
and they can't destroy their own property.
Right.
The policies that are being implemented now, Chris, is that police are going to have cameras. We've had them on cars for a long time, which is good. But now they're talking about body cameras. A lot of departments are moving in that direction right here in Northampton County.
And will they be held accountable when the camera's being
I believe,
switched on and off? Because
Correct.
part of the problem is that, some of the cities, I think New Orleans, a couple of other cities, have already engaged this policy. But the problem is, they're taping like 40% of the events, if you will, and if they're selective, then we're no further.
Well, that's the issue, is that the policies have to be that these cameras have to be on, et cetera. But the answer is, police are being held accountable. But sometimes people don't like the outcome of the jury trials. We have a jury panels in Trevor Martin case and others. They don't like the outcome of the case. But that's our justice system. There's many cases that I don't like the outcome, but I have to accept it. I'm the prosecutor. We lose some cases, but that's our system. And so nothing's perfect, but it's the best system on the face of the earth that I'm aware of.
We had some problems with our phones. Well, let me give you the number once again. Hopefully they're working. 1-800-426-4625. Hopefully we've gotten those up and running. If we want to get a telephone call in here in the last 10 minutes, let's go ahead and do so. Well, not all bad news for you, Kevin. The Supreme Court last year said that if someone seizes one of your client's cell phones, they just can't take that cell phone and rifle through the information. It's not like opening up a wallet and taking a look at some of the pictures in there. It's about going deep into data, your entire life. So in some ways, I know the Supreme Court sometimes gets pilloried because they're seen as conservative and they're anti-Fourth Amendment, blah, blah, blah. But, we have to at least take into account that there have been several cases in the last term that say we're drawing the line here.
Correct.
9-0 decision, by the way, that Riley case out of California.
Correct. I think the Supreme Court has shown that when it comes to rights issues, as far as whether or not the right has been implicated, I think that they are very much as far as making sure that the right is not tarnished. But when it comes to remedy issues, that's where I think you see the court shift to being more conservative. And what I mean by that is, whether or not the evidence should be excluded, or would they have found it anyway if the state doesn't adopt the federal good faith exception. So while there can be 9-0 on some of those rights issues, because a lot of those conservative justices are very strict constructionists, really believe in the letter of the law. But when it comes to what the remedy should be, that's when they start to lean really right.
Well, at just about every term, and this is the first Monday in October as we go live here tonight, and that means it's the first day of the Supreme Court term. And you can bet your bottom dollar that every term the Supreme Court is going to take a look at a Fourth Amendment case. That's how important it is, to our democracy. And a case is now before this Supreme Court that they're going to hear this year dealing with a broken taillight. We hear about that all the time. And this is actually about a brake light that was out in North Carolina. And an officer stopped someone based on the fact that a brake light was out. And I think he found a gun or cocaine or what have you. And of course, in North Carolina, the law is that if you have one brake light out, you're really okay. So the question now before the court is, we were taught probably even long before we went to law school that ignorance of the law is no excuse, but that may not apply to officers in this instance, depending on which way this U.S. Supreme Court goes. What do you think about that, Michael? Ignorance of the law is no excuse, but what happens when it's an officer who's made a mistake? Does that taint the entire process? Do we find that evidence is then tossed out?
I think that the court is going to toss that evidence, to be quite honest with you.
Do you really?
Yes, I do. I think there's a clear distinction in my mind between a mistake of fact and a mistake of law. As you mentioned, ignorance of the law isn't a defense. I don't know how the police who are asked to enforce the law can get a pass when they mistakenly do that. That being said, what Kevin mentioned was interesting in North Carolina is that the defendant may win if the rule is not implicated, But he may also win if they say the remedy is that the evidence should be excluded because they don't recognize the federal good faith exception to the exclusionary rule.
Right. Okay. And again, the good faith exception might be that an officer tried his best, did his best. He did something that crossed the line, if you will, but he did it in good faith. And that good faith exception, some would say, has chipped away at Fourth Amendment rights for the last generation, depending on whose ox is getting gored here. So I don't agree with you. Actually, Mike, I don't agree with you. I think the Supreme Court's going to find another good faith exception. Well, you do too.
Yeah.
So we'll have to wait and see. But once again, I think it is imperative to underscore the fact that not a year goes by that the Supreme Court doesn't take a look at search and seizure, because it's always evolving. And we're in such a high-tech society that you almost have to figure that with so many cameras and so much data collecting, do we have a generation now that may have a less expectation of protection under the Fourth Amendment? John, you're smiling. They're on Facebook, social media. They're disgorging every bit of information about themselves.
All of us absolutely have less privacy.
We know
you
that.
cannot go anywhere without being on a camera today.
Right.
And I'm not talking about this studio. Walking down the street, every store, get on a bus, go into a restaurant. I mean, everyone has cameras. And during intersections, you can't, with cell phones, if you make a phone call, it pings on a tower, we know where you're at. I mean, look, this is a very scary situation. Mm-hmm. Has it helped us in law enforcement? Absolutely. Okay. Has it also created a concern? It has created a concern as well.
And I think that Justice Sotomayor alluded to this in the GPS case that came out of Washington, D.C. when they placed a GPS device underneath the car.
Yes.
And she said that, ultimately the Supreme Court is going to have to wrestle with this, that, privacy, the definition of privacy is getting eroded every day. The more that we tweet and the more that we post on Facebook, it's something that the Supreme Court's going to have to wrestle with. I don't know how it's going to shake out. Obviously, a lot of it's going to have to deal with the composition of the court when that issue comes to it.
We're just about out of time here, but one other thing I have to bring up before we leave here today. There's another disturbing trend. We're seeing kind of the militarization of many of our police forces in the nation. It's not just an officer coming out to check things out. Often we see SWAT teams, men dressed in paramilitary gear. We're seeing more and more of that. I mean, police forces are basically getting their equipment for free from the military. Michael, shouldn't this disturb us as well?
I don't think so. I think John had mentioned it earlier. We live in a society where there really is a proliferation of guns. Criminals, bad guys are better armed than they were 20 years ago. I think what's important for the law enforcement agencies that accept this equipment is having strict guidelines as to when and how they can be used.
Well, I think that I slightly disagree with Mike in the sense that I think that it's a dangerous thing because, as you saw in the Ferguson situation, where you have thousands of unarmed people peacefully protesting and people showing up in paramilitary gear, all it does is ratchet up the situation, put people on guard. People who already are distrusting of police, now they see them showing up in army gear. What makes you think that they're there to protect and serve for you?
I'm sorry about our telephones tonight, and I want to thank my three guests for joining us this evening. Kevin Mincey from Mincey and Fitzpatrick in Center City, Philadelphia. Michael Schaller, former Major and Chief of Staff with the New Jersey State Police, now with King Kitrick in Brick Township, New Jersey. And as always, our prosecutor, John Morganelli with the District Attorney's Office in Northampton County. Thanks for joining us this week. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Schaller PC. Since 1977, its mission has focused on one thing: protect the rights of individuals harmed by others' negligence or corporate misconduct, representing people injured by dangerous drugs, faulty products, and whistleblowers in False Claim Act and qui tam matters. King, Spry, Herman, Freund, and Fall, serving its clients in family law, business, personal injury, and school law for over 30 years. If it's a big project in the Lehigh Valley, it probably has King Spry's name on it. And the Legal Intelligencer, an American lawyer media company, and the oldest daily legal newspaper in the United States.